Next we have Jean Teillet. Jean Teillet is a partner with Pape, Salter, Teillet, LLP, and is called to the Bar of Ontario, BC, Northwest Territories, Manitoba, and Yukon. She specializes in Aboriginal rights litigation and negotiations. Teillet is the chief negotiator for the Stolo Treaty being negotiated through the BC Treaty process. She was counsel at the Supreme Court of Canada in Pauli, Taku River, and Beckman, and acted as counsel for interveners in many other cases, including MMF, Cunningham, Haida, Delgamuukw, Blay, Paul, and Ben. Teillet also represented an intervener in Daniels at the Federal Court of Appeal. She is the author of Métis Law in Canada and a former treasurer and vice president of the Indigenous Bar Association. Teillet is the great-grandniece of Louis Riel.
So I'm reminded of my early beginnings in Manitoba. My first job was with CKRC Radio. I had a little 1-minute blurb every day when I was 17 here in Winnipeg. It went out over CKOC in Ontario and CKCK Hamilton, and it was called In Touch with Today. It was Jean Teillet in Touch with Today. And I was a 17-year-old blabbermouth who got to spin off whatever I wanted to say any day, and the station manager was very generous with letting me babble. So here I am back in Winnipeg again, where I'm born, right here at the Forks in St. Boniface Hospital. So I want to say what a pleasure it is to come home and be here. Now, the University of Manitoba is not my alma mater, but I'm delighted to be here. I see lots of familiar faces in the crowd as well. So thank you for inviting me, and it's an honor to be here. I'm sorry I wasn't here yesterday. I was at the treaty table negotiating all day. So I apologize if anything I say is repetitive of what you heard yesterday. I wanted really to talk about 3 cases. I know you were talking about Chilcotin and Chilcotin. I'm going to mostly stay away from Chilcotin. And since you just heard a whole talk on it, that's probably a good thing. But I wanted to talk about Chilcotin, the MMF case, and Daniels. And despite the fact that Mr. Gallagher, every time he mentioned MMF, sort of looked at me as if it's my case, it wasn't my case. It was Tom Berger's case from beginning to end. I was an intervener at the Supreme Court of Canada, so I can't take any credit for the Manitoba Métis Federation case. And to be honest with you, if I'd been running it, I would have run it totally differently. I would have had an expert or 2. Anyway, we won't get into that one too much. But I do want to talk about the Chilcotin case. I do want to talk about the MMF, and I do want to talk about Daniels. And also, just to pick up on something that Mr. Gallagher said, I have learned over the last 20 years of being a litigator that winning and losing are very debatable ideas when it comes to court decisions. A win is sometimes a loss, and a loss is sometimes a win. And so, for example, when you look at the Haida case and the Taku case, Arthur Pape and I were lead counsel on the Taku case. These are the big 2 consultation cases, and our case was actually running ahead of Haida all the way. They only got joined together at the Supreme Court of Canada. So we were the ones who cooked the idea of consultation and accommodation first, and it went to the Court of Appeal in Ontario, in British Columbia. And I have to tell you, when the judgment came out at the Court of Appeal on Taku, our own analysis of it was that the Court of Appeal was so pressed to bring it out quickly because Haida was coming right behind it. And the judgment is virtually incomprehensible, so bad that the editor of the Dominion Law Reports phoned me and said, okay, I've never done this. I've been editor here for 35 years, and I have never had to phone a lawyer and ask them, what the hell does that mean? But that's what she did. So That's what I'm saying to you. You don't know when a win is a win and a loss is a loss. Anyway, we went up, we won at the Court of Appeal. We both get together at the Supreme Court of Canada. The Supreme Court puts the whole consultation thing, basically frames it on Haida, which is why everyone talks about Haida today. But technically, Haida was a win, right? They won the big thing. Now, I think that we all won because we won the big theory. But in fact, in Taku, we lost. Right? The court said, no, you've been consulted with enough, they can go ahead and do their thing. But I want to tell you, we started that case because we were trying to stop a mine and a road. Not particularly the mine, we didn't really care about the mine so much, but the road was so damaging we were trying to stop it. And my motto was this: every day there's no road is a win for Taku River Tlingit First Nation. Every day there's no road, that's a win. Okay, so the Supreme Court of Canada decision comes down in 2004, and to this day, there's no road up there, right? So, but we lost that case, all right? Haida won their case, right? Clear statement that the harvesting of the wood and the transfer of the tree license was a violation of their rights. They won. Clear-cut logging continued for years. They had to take the government to court again. So they won, and they couldn't capitalize on it, and we lost, and we are still able to capitalize on that. To put it in another context, we won Pauli in 2003. 5 years later, we had to take every single province back to court to get anything out of Pauli. And in this province, it's particularly gripes me because everybody else in Canada says, oh, well, we don't have any Métis here. Métis are all in Manitoba. Those all those Red River Métis, you know. Everybody else says that. Everybody. Well, there's Métis in Manitoba, but there aren't Métis here. And in Manitoba is where we had to take a trial and start all over again with the big, long, historical case in Manitoba. And that was, I thought, particularly outrageous that the Manitoba government would not implement the Pauli decision. And we had to go through the Goodon case, and then yet another case called Beer, which was about forestry before the Manitoba government would even sit down and talk to us, right? So it's kind of a thing I've learned about litigation. When is a win a win? When is a loss a loss? Sometimes we've been able to take 5 words out of a total loss, what you might call a loss, and make a lot out of it. And other times, I think, as the gist of what you just heard about the Grassy Narrows case is that whether it's a win or a loss is irrelevant. Does it provide some theory and language and help us to move some of these yardsticks forward? So on that one, although I'm not going to talk about the Grassy Narrows case, I agree with Mr. Gallagher that it does provide us with some new tools. So I want to start, before I talk about the 3 cases, Chilcotin, the MMF case, and Daniels, I want to start with what I see as the world before these cases. And I just want to give it to you in sort of my 5-fold basic theory, which was this was the way we looked at the world before these cases. Number 1, the Crown owned all the land and all the resources in the country. That was the big premise, right? Number 2, Crown had jurisdiction to make all the decisions about how those lands and resources would be used. Number 3, the Crown got all the benefits, financial and otherwise, from the use of those lands and resources. Number 4, the Crown was, once it signed treaties or entered into scrip, but in any event, in one way or another, Crown could finish its business with Aboriginal peoples, right? It could do something that meant it was done with you. In other words, there's a divorce concept going on. The Crown could divorce itself from Aboriginal peoples. That was the theory. Either by means of treaty or scrip or whatever, they could sign something and then they didn't have to deal with you anymore. You were finished business. That was the world before. And the last one was, and this is particular to the Daniels one, that they only had responsibility for status Indians, right? And then in 1931, okay, well, we got to deal with the Inuit too, but that was it. Everything's been reluctant. But basically the idea that they could decide who were the Aboriginal peoples they could deal with. And what I'm saying to you is that those 5 theories are, I think, tossed right out the window by these recent series of court cases. And in fact, I think that for many, many years, the Supreme Court of Canada has been shining a light on how unacceptable these theories are and the need for them to change. So I think all of these assumptions have been fatally undermined by these recent cases. Now, I think that June 26th, the day Chilcotin, I'm going to start with Chilcotin, the day Chilcotin came down was a landmark day to me because it was the first time I actually saw the unicorn. So that's what I used to call Aboriginal title, was a unicorn, right? It's this lovely, mythical, beautiful beast that nobody had ever seen, right? Never, it was just only existed in theory, that it was a beautiful thing. But until June 26th, not a single grain of sand in this country had Aboriginal title attached to it. And so suddenly, the unicorn is real. That's an amazing, amazing thing. And it's important, and it's the most important thing, because up until now, all of these cases we've been talking about, they've all been about money or harvesting rights, something like that, right? And to tell you the truth, since something like 80% of our population lives in cities and doesn't know what a moose looks like, they don't care if you can go hunting up north. They don't care if you can go in the spring goose hunt here in Manitoba, which is so important to everybody. They really don't care. In fact, it was one of the biggest shocks I had during the Pape case was that when we won at the Court of Appeal, and that was a moose hunting case, right? We won at the Court of Appeal, and it actually made it to the front page of the Toronto Star. And I said, wow, I don't think there's ever been a moose on the front page of the Toronto Star before. It wasn't really about Métis, it was about, really, do you think people south of the 401 actually care about that? The truth is they don't. They don't really care, so it's fine. So you can have that. But this, Chilcotin, that's different. Land, tangible, hard land. That's a big different thing. And I think for all the lawyers in the country who know what it means when the court says the resources vest in Aboriginal peoples, we know what that means, right? That's serious business all of a sudden. So June 26th was an exciting day. So what does it mean? I think, and I'm not going to talk about interjurisdictional immunity, okay? And I will forever be annoyed with Dale Gibson for inventing the words because he's the one who coined the phrase. But what does it mean? I would say Chilcotin means one thing. As of June 26th, the Crown in this country, and particularly in British Columbia, but all over the country, owns a lot less lands and resources than it thought it did on June 25th. Okay? So that's, I think, true. And lest you think that's only in British Columbia, it is not. The whole Algonquin territory in Ontario is unsettled. There's no treaty covering that area. All the treaties in Eastern Canada are peace and friendship treaties. They are not extinguishment treaties about lands and resources. So we have huge swaths of this country where treaty is unextinguished. Treaty is also unextinguished in the north with the modern land claims agreements because all those treaties are proceeding on the basis of non-extinguishment of title, as well as all the BC new treaties, Nishka, Tsawwassen, Manof, the new ones that are being signed, Yale and Tla'amin. Those are all non-extinguishment treaties. So we have a lot of unextinguished Aboriginal title in this country. So the idea that the Crown owns all the lands, which is what they thought prior to June 26th, I think that's changed. The second thing is that Chilcotin did is that decision-making authority, I would say, is very conditional in many parts of the country. Now, Mr. Gallagher talked about consent, and I would look at that as well, and I would say that the cost of consent has now gone up, right? It's really gone up. And why has it gone up? Because the Supreme Court said something very important in Chilcotin. They said that Aboriginal title is territorial in nature. So the very fact that Aboriginal title is territorial in nature gives us an idea of what it cost. Now, this is why I think it actually has some application on the prairies here and in the numbered treaties and in the full extinguishment treaties. It's not so much that you can go back and reinvigorate your title. I'm not suggesting that. I'm saying that when we're into the honorable taking up clauses, we now know we can cost and put a dollar value practically on what Aboriginal people gave up when they gave up title. So if they want to do Ring of Fire now, I would suggest the Aboriginal people sitting at the table have a stronger hand to play. If you want to play, you want us to be a partner in this discussion. If you have a prayer of getting this thing moving, you have to come to us with an understanding that we know what our value is and we know what is a reasonable role for us to play at the table. And I think actually consent is playing a role in some things here. So we've negotiated equity arrangements with Ontario Hydro for the Moose Cree, for example. And believe me, if you want to talk about problems, and I know in Manitoba, the hydro was the devil, right? For years and years and years, right? Because of the way they dealt with Aboriginal peoples, because of the horrible flooding and the horrible abuse of Aboriginal people's lands and completely wiping out communities. The same thing happened in Ontario. And so for us to actually be able to sit down and create a working relationship with Hydro in Ontario, that was nothing short of, I don't know, sometimes I think it was a little bit of a miracle, but it was a long-term coming to get them there. But it's really interesting partnership watching because the Aboriginal people are on them all the time about sustainably working on that resource development. So I think that's an important thing to say, that the cost of consent has gone up. And look at it from government's perspective. So I don't often have sympathy for premiers, but I think, Christy Clark in BC, she's sitting between a rock and a hard place. So if they don't get consent from Aboriginal people now, because look at Chilcotin, okay? They're the hard case in some ways. They were, it's easy for when they proved title because there were very little overlap things, right? So their exclusivity thing was fairly easy to prove, right? The hard case, because they're semi-nomadic, they traveled over a long period of, along a large territory, and they were a small group of people. That's a hard one. If they can prove title, I just put it to you, which Aboriginal people in this country cannot prove title? Everybody can. I'm working for the Stalo at the Stalo table. They had villages of 10,000 people, 10 villages in a 7-mile area of 10,000 people when Simon Fraser came down the river. Are they not going to be able to prove title there? Of course they can. Can the Tsilhqot'in prove title? Haida have it a breeze, right? They're on an island. No overlaps, right? So there's no problem with that. But I think the message is clear. If the Chilcotin could prove title, everybody can prove title. So what are we going to do here? So why I'm saying Christy Clark's between a rock and a hard place is, okay, if they don't get consent from Aboriginal people, right? They go forward and they approve a mining project or a forestry project, right? And that group doesn't agree. And in fact, they so disagree, they take it to court, just like Chilcotin did, and said, we have title. And they win their title. Then the government is vulnerable, A, to the mining company that they granted the lease to, right? Mining company probably could and probably would turn around and sue them. You promised us this. This is worth this much money. You owe us that, right? And then the Aboriginal people can sue them to say, you took our lands and resources, and that's our title, and you took it wrongfully, so that they can get it. So where does that drive us to? I think it drives the government to say, if you don't get consent, you're stupid. You're just stupid, Like, I used to, you're not supposed to call people retarded anymore, but I really don't worry about it with government. Because, the definition, I believe, of being mentally challenged is if you have to hear something 16 or 18 times and you still don't get it. I mean, how many hundreds of years have we been at this and they still don't get it? I think we can suggest that they could actually employ a little more brain power in their decision-making processes, right? Something that would actually look for consent with Aboriginal people. So I think that the other thing that Chilcotin does is it created an era of uncertainty in British Columbia as to whether business can go forward. Now, the province doesn't like that, the business community doesn't like that, but it's good for Aboriginal people because we can push and say, you want certainty? come and talk to us. Come and talk to us. Now, I was in the room at the All Chiefs meeting in August after Chilcotin came down, and the Chilcotin chiefs were there. And I thought that was really interesting to listen to them. So they have some interesting challenges in front of them, really interesting challenges, right? They have a very large territory, which they now have Aboriginal title over, which the court said is management and decision-making, proactive use and management of that land. But they have 6 Indian Act bands that only have jurisdiction over the reserve lands that they have. They have no management structure, no governance structure to make those lands and resource decisions. And when I saw those 6 chiefs get up and talk, I didn't see a lot of agreement between them. In fact, I was astonished that they kept it together for 20 years. They did, to their unbelievable credit. They kept it together. But already you could see 2 of the chiefs saying, we want development, and 4 of them saying no. They're going to have challenges in the future, and one of the biggest challenges they have is that they're stuck in the Indian Act governance system with its limited jurisdictional powers. So there's trouble down the road because of the structures that we've set up that are going to hamper them. Now, is the Chilcotin application limited to First Nations? I have to tell you that I've been, since June 26th, in about, 10 various groups of multiple lawyers talking about Chilcotin. And I know my own partners, were 7 of us. We spent 2 full days sitting, 7 of us. And I represent the Stalo, so they're 7 First Nations in British Columbia with unextinguished Aboriginal title at the treaty table. We represent Yukon First Nations who have modern-day land claims agreements with some of their title extinguished, but some not. We represent the Tsilhqot'in in the Northwest Territories who have totally unextinguished title, but a modern treaty. We represent several First Nations, like I said, Moose Cree in Ontario, who are one of the historic Treaty 9 bands, extinguishment treaty. We represent Métis, who have title, title in Manitoba. So all of those present different applications of Chilcotin. What does it mean in each one of those kinds of situations? How does that play out? So I was asked here to speak about the Métis, so I wanted to talk about that a little bit, about how I think it will play out. And I think you can't divorce it from the Manitoba Métis Federation case. So let me just preface it first with the Manitoba Métis Federation case and Daniels, because nothing's going to happen until Daniels gets settled. That's the problem we have right now. So Daniels, for those of you who don't know, is the classic Canadian legal issue, which is this: is it a federal or a provincial responsibility? That's just classic. And for those of you who are in law school, we all took it with the chicken and egg marketing cases and the light beer case and the margarine color cases and yada, 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 I love the margarine color case because I don't know if you know this, total aside, but I don't know if you know this, but David Lepofsky was the lawyer on that, and he tells a wonderful story about going to the Supreme Court of Canada. And this was, for those of you who are too young and don't remember, margarine couldn't look like butter, right? And it used to come out with a little package of dye in it, and it was white, and you had to mix it up to make it look like I'm showing how old I am, right? So anyway, so it goes to the Supreme Court of Canada, and David Lepofsky's the lawyer, and the question is whether the butter companies can keep a monopoly on the color of butter. Can you think of a more stupid question, anybody? To go and take up all those resources and go all the way to the Supreme Court of Canada? Okay, but it did, okay? So anyway, the funny part of this is that David Lepofsky's blind. And so he's taking a whole court case to the Supreme Court of Canada about color, and he can't see color, right? Color means nothing to him. So he's standing at the Supreme Court of Canada, and the Crown lawyers are up first, and they keep saying, and if my lords, back in those days it was all my lords, if my lords would turn to page 40 in tab 3 of the buff-colored factum. And after a while, David had never been to the Supremes before, and he says to his articling student, what's buff? and the articling student says, I don't know, I'm colorblind. So you had a colorblind person and a blind person taking a case about color to the Supreme Court of Canada. So if you ever think that the law is futile and maybe a bit of an ass is what they say sometimes. You might be right. And that was a complete aside, and I don't know. Oh, Daniels, right. Okay, so Daniels was why I went there first. So you can't understand, we can't talk about the application of Chilcotin and the MMF case until we talk about Daniels. So Daniels was, like I said, the classic, is it a federal or provincial responsibility? So, okay, so this is about are Métis and non-status Indians within federal jurisdiction or provincial jurisdiction. It's been described by the lower court as jurisdictional football. I really object to that because, you know, football, you want the ball, right? Like that's what the game's all about, is getting the ball, taking the ball and using it. And this is not, in fact, we don't have a sports analogy here because I don't think there's a single game where the object of the sport is to not touch the ball. Like, or to drop the, I don't think we have a single game where that happens, right? So I don't think sports analogies work here because that is the fact with Métis and non-status Indians. Pardon? Dodgeball? Oh yeah, maybe. Except they're throwing it at, yeah, maybe, I don't know. Okay. Okay, I give up. Maybe I'm glad somebody can think of one. But I don't think the things like football and hockey and everything work, right? You know, or soccer or anything like that. Okay, so the trial at Daniels was, this is a case brought by the Congress of Aboriginal Peoples, and the Congress of Aboriginal Peoples is what we call a pan-Aboriginal organization. They represent Métis people, they represent Indians who are status Indians who live off reserve, and they represent non-status Indians, okay? So they've got a mixed bag of representation, hotly disputed by the chiefs who say they represent all status Indians and the Métis Nation who says it represents the Métis. So you will note that at trial none of those groups were there. It was only the Congress of Aboriginal Peoples. So the case was brought from their perspective, and their perspective is, to my mind, a little muddied about who the Métis are and who non-status Indians are and whether there's a difference between the two. So the trial judge said that, to put a long story short, the trial judge said, yes, Métis and non-status Indians are within federal jurisdiction. They are Indians within the meaning of Section 9124, which says Indians and lands reserved for the Indians. So this case is not about and the lands reserved for the Indians part. It's only about the Indians part, okay? I hasten to note all the way through this case, everybody was pretty clear that finding Métis and non-status Indians to be Indians within the meaning of 9124 does not mean they are culturally Indians. So we have to remember that Indians is not a culture. It's a legal term and only a legal term. We have Mohawk, we have Anishinaabe, we have Cree, we have Haida, we have the Tsilhqot'in, we have all kinds of Aboriginal peoples, but nobody in this country was an Indian the day before Columbus created us as Indians, right? So the idea that they are Indians within the meaning of 9124 is only about putting them in the legal category under federal jurisdiction. So the court at trial said, yes, they are under federal jurisdiction. That got appealed by the Crown to the Court of Appeal. And the Court of Appeal said, okay, well, and it was almost a toss-off. Chief Justice Noel was there, and it was just complete toss. Métis, yeah, it's fine, no problem. It was like a non-question for the Court of Appeal. They didn't even want to talk about it. It was just such a given that what they were talking about, Métis who are peoples within the Paoli concept of a collective, of a people with its own language and culture and everything. No problem there in 1924. Court of Appeal's whole problem, and you could see it from the minute they walked in, was with non-status Indians. They were saying, well, who's a non-status Indian? What does that mean? How on earth can we make such a big, broad, sweeping statement when, by some definitions, everybody in Canada is a non-status Indian? Because the idea is that you're not on a registry. Okay, well, then everybody other than the people who are on that registry is a non-status person. So they were very concerned about that. So what we saw after that was the government and Congress of Aboriginal People playing a lovely little game of chicken, which was really interesting. Who was going to appeal, right? Who was going to appeal this? They waited and waited and waited and waited. And finally, the Congress of Aboriginal People caved 4 hours before the deadline to file the notice of appeal, and finally filed their notice of appeal. And then the Crown, and so they appealed on the non-status Indian issue. So they appealed saying they accepted the fact that Métis were in, and the court was right on that, but they wanted to appeal, the Court of Appeal saying that non-status Indians weren't. So that was their appeal. 2 weeks later, late, the federal Crown files its response to the to their leave application, and then slips into their response a cross appeal on the Métis stuff. So the court just granted it. Today's Saturday. I've been traveling so much I've lost track of it. Thursday morning. So we now have the Supreme Court of Canada is going to hear this. So I suspect, look at the time, we're in November. I think by probably this time next year we'll be before the Supreme Court of Canada arguing the Daniels case, whether Métis are within federal jurisdiction or provincial. Okay, why do I say we have to have that resolved first? Because one of the problems we're having with the Manitoba Métis Federation is that the feds won't come to the table since the decision came down. There is absolutely no traction, despite the press about Paul Martin and the lovely people trying to do something. Nothing is happening. Nothing. Myself, I think the feds are in a bind, right? If you take a look at the Supreme Court of Canada decision, what does it say? It says you breached your obligation, your constitutional obligation to provide the Métis with 1.4 million acres of land. You didn't do it. And what was the breach about? Delay. Okay, so you delayed too long, and that's why we're going to find that you breached. There was a systematic delay that breached. So here we are. Decision came down almost 2 years ago, actually a year ago, and the federal government won't talk. They won't negotiate. And so I think they must be sitting there saying to themselves that they have to do something. And they must know that if they don't do something, they're going to get caught again for not doing anything for delay. So I think they're going to have to do something, but I think the problem is that they're still sitting there going, well, we don't have any jurisdiction for the Métis, so why would we sit down and talk to them? So that's why I'm saying I think Daniels is going to have to get settled first, so then the feds are going to be able to stand up. And they're all looking for cover, political cover. Right? And so the feds are going to be able to stand up and say, we didn't want to have to do this, but we have to because the courts have made us, right? So the court's going to make a decision and say Métis are federal jurisdiction, and then everybody's going to feel like, okay, well, we have to sit down and talk. So their cover is going to be blown after the Daniels case comes down. And I'll go out on a limb and say that I think that the Supreme Court of Canada is probably going to come down the same as the Court of Appeal did with respect to the Métis. I don't know if I want to make any prediction about what's going to happen with the non-status Indians. It's too, there's too many possibilities out there. But I think with respect to the Métis, they won't have any problem with that. If you're looking for I just finished writing an article that's about to be published in French, and I have to thank MA for helping me with the French translation. My French not being all that good. Where I wrote about the 9124, and one of the deeply troubling things that's following through this decision is the fact that people are calling 9124 a race-based provision. I find that appalling that we would have systemic race-based constitutional provision in this country in 2014. At least in the United States, they got rid of their Jim Crow laws. You know, South Africa got rid of apartheid, which was their embedded constitutional and legal racism. If we have the courts in this country saying that 9124 is a race-based provision and thinking about it in terms of race instead of in terms of ethnicities, we got a real problem. So anyway, that is going to be published in the new year by St. Boniface College in French, for those of you who read in French, and probably by the Indigenous Law Journal in English coming up soon. So, and if you want me to go further on my high horse on that, I will. What is going to happen? I want to suggest what I think is the central contribution of the Manitoba Métis Federation case about the honour of the Crown, about Chilcotin, about Aboriginal title, and about Daniels saying that all Aboriginal people are there. I think the central idea here is that the courts are saying that the foundational, those 5 premises that I started with, are unacceptable, and they are creating a new idea here. They're insisting on inserting Aboriginal people in the governance of this country, in lands, in resources, in responsibilities, in recognition. And I think that they've been doing it gradually for a long time. And in fact, I think they've been hammering harder and harder and harder as time goes on. I think they started in Calder very tentatively, Aboriginal title, some of the Supreme Court judges, Aboriginal title, yeah, maybe it does exist. Some of them, I don't know. Pigeon, of course, coming up with his, technical thing in the middle. But basically, since then, and particularly since Section 35, I think the courts have been saying, look, government, we keep telling you, you've got honour of the Crown, you have to deal with people, you have to deal honourably, you've got to do this. They keep ignoring it, they keep backtracking, they keep saying that they won't do it or they just ignore it. Then the court comes down with Haida and Taku and says, okay, you're going to take so long to settle these claims, you're not going to do it? Okay, we're going to give you an obligation that you have to take on in the meantime. And now we have Chilcotin, them coming again and smacking the government and saying, you've got to do something here. So I think that what we have is dismantling what I would think of as government silos that have really fostered the exclusion of Aboriginal peoples. So the idea being that, oh, well, it's this department over here dealing with this, and we don't deal with Aboriginal people, we only deal with fish, right? Or we don't deal with Aboriginal people, we only deal with mining, right? Or we only deal with this particular thing. And the ability to, because of the silos of governance and the whole structure of governance, that they could very, very ingeniously always find a way not to deal with Aboriginal people. I think that's what the court is systematically dismantling. And I think that what they've done is they put a big new chess piece on the board, and you're not a pawn anymore. Those of you who are the Aboriginal leaders in the room, we're not pawns anymore to be moved around by everybody else. You're a significant piece on the board now with power, with jurisdiction. Now, that presents challenges for our side of the table. It means we got to get our act together, because I'll tell you what happened at the All Chiefs meeting afterwards when I met with government, and their response when I said what I had earlier said to you, which was that Aboriginal people will be able to prove title everywhere. So I'm saying, well, the Stalo, they're going to be able to prove title. And you know what the government's response was? Oh, you'd never be able to keep it together to bring an action for it. Okay, that's not a principled stance on anything. That's just a political risk assessment. That's all that is. So all I'm saying to the leaders here is that we have to act like the Chilcotin did, bury our differences and push forward, because that worked. And that's what will happen here. So the idea is that the government knows that we can prove title. The government knows we can do it. They're banking on the fact that we're too divided to assert our power and to actually make something out of those court cases so that we can play a role in this. And so what's the other thing that happens here? I think Chilcotin gives us hammer to get shared a role in decision making in this country, a role on your title lands as to what is going on. Not necessarily total veto power, but a role, a significant say in what's going on, shared decision making. I think that's what can come out of this. So I think this is going to hold for the Métis. I think what's going to happen here is that the Métis are, as always, we're like 10 years behind. I have to tell you that strategically it's my plan that we stay behind because, quite frankly, First Nations have more money and more power and more ability to take these cases on. So if you guys are out there creating Aboriginal title, thank you. I'm going to do a little free riding here and make some decisions when I think that the ground is ripe to move forward. So I think that what we have here is before. Remember I had those 5 premises? I regard those as the emperor's clothes. You know the story of the emperor walking around and having no clothes and everybody pretending that he did, right? Until some little child who wasn't in on the game said, how come he doesn't have any clothes on? I think that what's happening with these cases is that they are stripping away the clothes off the emperor, and the emperor has no clothes anymore. The emperor still thinks he's got clothes on, and he's pretending he does, but the truth is that each one of these is taking them away. I think it's a subtle and slow and revolutionary move. And I call it revolutionary, but I don't mean it in the sense of taking up arms and fighting and like that. But it is revolutionary to fundamentally change the power structure in this country, and that's what's happening. On a daily basis, inch by inch, piece by piece, we are moving forward. So I know a lot of people think it's not fast enough and it's not working as well as it should, and there's still a lot of problems, which there are, but I'm old enough to look back to the 50s and 60s and say, it's a hell of a lot better than it was back then. Things are better, we're moving the yardsticks forward, right? And so this is where it goes next. I think sovereignty in this country, and that's the other thing, right, is that the idea that they owned the resources, that they had management and say, that they got all the benefits from it, that they could write you out and say, and we're done with you, that is, in essence, sovereignty. That's what that was, their assertion of sovereignty. And what is being dismantled here is piece by piece, we're pulling off the legs off. I've muddled about 25 metaphors here, but we're like pulling the legs and the wings off that idea of sovereignty, and not totally throwing it away, but reshaping it and recreating it to be joint sovereignty. That's what we're doing here, is creating that. And we've got a long way to go, but I think that the foundation points are here. So I think that the most encouraging thing for me out of this is that I think, to use my last little metaphor, I think that government is starting to feel the wind blow, Paul Simon wrote that song, Graceland, where he says, losing love is like a window in your heart. Everybody sees you're blown apart. Everybody feels the wind blow. Well, and I wouldn't call this losing love, but I would certainly say that the government is being slowly taken apart, and they are starting to feel the wind blow. So I think, and I loved Mr. Gallagher's list of all the cases that were our wins, because I've been walking around and saying, this is a project for a graduate student. Somebody should sit down and start from 1982 and go through all the Aboriginal rights cases and figure out how many are wins and how many are losses and cost estimate it. And then sit and tell the government, you look at how many millions and millions and millions of dollars you are spending on a losing strategy. No business on the planet would do it. They would have bailed years ago. It should tell you something about the measure of legal advice governments are getting, or maybe they're getting different advice and they're not paying attention to it. But the fact is that if somebody actually published something that showed how much this is costing Canadians, I think that we would perhaps start to change things. So I want to thank you for that, and that's it. Thanks.
Now, we had a couple of people that were here yesterday that were in the queue for questions. So we'll let them go first. So we've got 2 in the back, then we'll go to Ken, then we'll go over here. So we've got 4. Hopefully we'll get through all of it.
Good morning. I greet all our elders that are here, all our relations, Aboriginal and non-Aboriginal. My name is David. I'm from Pimichikamak, our traditional government and territory. For the record, we are not an Indian band in accordance to the Indian Act. I just want to go back a little bit about the cases here that have been discussed, the nuts and bolts of it. And in listening to the legal perspective and understanding within this domesticated constitution, and one of the things that's really struck my people, and when I speak for Pimichikamak, is that language matters in how we present those rights. And I heard our elders speak here yesterday to feel that pain of that sacred responsibility that our people still have to the land and the governing of that land and its people, regardless of what tribe they are. We're losing a lot of our elders and that wisdom they carry, despite the different customs. I'm a student of oral government and oral history and inherent lawmaking and jurisdiction from our elders. And I've been watching and studying this British Commonwealth system of law evolve and the efforts to try and interpret inherent jurisdiction and where these Supreme courses come from. What I see is the narrow scope in limiting the interpretation of what those rights are. And what I mean by that is I do not see international language here in these rulings when it comes to indigenous nations and indigenous peoples. Indigenous is very different from aboriginal. Ab meaning first, original. And this notion and this concept of First Nation, that's a political label that's been put on us. Historically and scientifically, we found artifacts that are 10, 12,000 years old. We've always been in this island. We've never come from anywhere. We're not the first nation to come to this island. So I think it's only appropriate that concept is put aside and we don't say it with arrogance, because we're not a First Nation. We're a sovereign peoples who have an identity, a language, culture, customs and values, and more importantly, land. We cannot call ourselves nations if we do not have land and jurisdiction to that land. That's what enabled our ancestors to enter into that treaty with the British Crown back then. The messages I deliver from the elders that I work with said, there is only one treaty with Britain. There's not 11, even though they've been categorized as such by region. But each area has a responsibility in what they need to do, but not just for themselves alone, but for all 11 areas. Our elders kept telling us, go home. Go home. Go back and learn your history, your foundation of rights. your lawmaking, that's sacred. So one of the questions that comes to me listening to all these nice presentations is, do we have that right to bring in such a sacred unwritten constitution into a domesticated framework? What we see is a bunch of empty boxes in Section 35 of the Constitution Act of Canada. And it goes back to the 1969 White Paper policy of assimilation, where they'll negotiate Indians out of existence. Is that legal? Is that appropriate? Is it consistent with the international community? So many things that we talk about here today, it's a good step forward. It's a little battle that was won, but we haven't won the war in terms of bringing the law of fairness, the law of equity between the two nations that entered into that relationship. Because the standards are already there, how the Crown is supposed to conduct themselves between the nations. What we see from Pimichikamak, like these trail-breaking Supreme Court rulings, after our ancestors entered into the treaty in our territory, they mapped out an area in 1877. That's the only known map that the Surveyor General of Canada signed off, called Pimichikamak Territory, which Supreme Court called Traditional Territory. It was about a tribe. It was about a people. And to correct the information that was here yesterday, political organizations like MKO do not represent and speak for Pimichikamak as an inherent government. They are political arms of Indian affairs because their mandate is to deliver normal programs and services. Legally, they cannot speak for Aboriginal rights and title. And I believe some of these Supreme Courts have reaffirmed that. And it's not out of disrespect we say when people get elected under the Indian Act in accordance to Canadian law, a chief and council become agents of the minister. So this whole consultation process is a sham when it's an institutionalized conflict of interest. How can you put a fox to guard a hen house when you're a federal agency? Indian reserves do not have jurisdiction to the traditional territories of a peoples because they're legislated by the Indian Act. Our people are starting to do their homework, but is there going to be a willingness to come to the table to do these things right? Because what we found in our journey, there's only been two options from the Crown. To either frustrate an Indian to death through all legal means, or if you have deep pockets with deep money, they'll say, come to the table, let's talk. And that's what's happened. And when it comes to consultation, the onus is on the Crown to prove how they're going to minimize the effects on Aboriginal rights and title. Not the Indian. But what's happening? Resource developers are running around consulting, which is not appropriate. We just come to share that with the students that are here. Because when you look at the order of hierarchy, inherent being the highest, the treaty law between the two nations being next, the international community, the Canadian Constitution, the federal laws, the provincial and municipal, That's why that constitution is within. I don't think no two-legged person will have that right to try and bring in that inherent right and law into a constitution that's man-made. Because we don't even have a say how that works, because it's very sacred and it's not an appropriate place to discuss that here. The elders will scold us for that, putting things in writing. We will kill the spirit of our nation, of tribes, with all good intentions. Well, you have to bring you that message from our tribe, because we are part of a much bigger Cree confederacy. I cannot go speak for my fellow tribes that are out there, because their customs and values are different as well, their lawmaking and government processes. But that system of government is there, that foundation is there, but it's each up to every individual to know it, to go back and research it, but to walk it and live it is another challenge. Anybody can talk about a lot of these sacred things, but if you don't walk it and live it, then I don't even know if we have the right to talk about it. So, and that's what I see in these consultation processes that are here. Our elders right now, the leftover surviving ones that notice, are very worried. And we're all in it together. Nobody's going away. Our ancestors already made that treaty with your ancestors. But we have to understand those sacred responsibilities, what that means. So I just wanted to share that here. That's what I wanted to share in terms of the processes involving consultation, always leading up to these Supreme Court challenges. Our people already have that map that acknowledge their very existence as a people, as a tribe. Unfortunately, our brothers had to fight it all the way for over 20 years, and to have the Supreme Court tell the Crown saying, hey, get your act together. These people are real. This is their home. You have to start living up to your treaty responsibilities. It's not about how much money an Indian wants. It's not about this, it's not about that. What are we going to do to work together? Because at the end of the day, it's those elders who are our own traditional experts, they're our own lawyers that should be interpreting that sacred law. So I just wanted to share that with everybody here, because in our custom, when you don't feel right about it inside, you have to share it and let the people know, face to face. We say, they sutastamit, kitawitamot, isimusitay ninino. Kito. A lot of these things I share with you is from the words from the elders when they've called last night, and I told them what was going on here. They said, you have to tell them. Some may not agree, some may not like it, but at least you would have done your job telling them what we're telling you right now. But thank you for listening this morning, and forgive me if I offend anybody. That's not my intent. But we wanted to share that because we're concerned about the way everything's been going here. Thank you.
Thank you. I want to thank the Cross Lake person for saying what he said, because it's very, very true and appropriate. I know that this is an academic session, and that questions have been asked as a result of what all over the country, as a result of what the Supreme Court of Canada has decided in these two very important cases. based on what I see, policy, not necessarily law. But nonetheless, there are decisions that are relevant because we need something to cause governments, the business communities, or the business community to do the things that need to be done to ensure that fair access of the wealth that's being generated by resource extraction benefits the original owners of the land, the First Nations people, in a fair way. I always use the number $1 trillion. What's the fair share of $1 trillion? It's something that needs to be addressed. And I believe that these judgments will begin that process. Now, on the issue of Daniels, a good friend of mine who started the litigation quite some time ago, and that he was a big player in the constitutional reform process, and that his legacy will be whatever the court decide in the litigation that he started. The word Indian, Métis, and Inuit, the words are found in the Constitution of Canada, Section 35. Now, I've been texting back and forth with my good friend Paul Chartrand, who was here yesterday. He was not here today. I've asked him, Paul, if the Supreme Court of Canada decides that the word Indian in Section 35 includes Métis, what becomes of the word Métis in Section 35? And that the Indian Act defines who Indians are. For many, many years, that's been an ongoing definition. It's changed over time, and Indians and lands reserved for Indians. Now, the Métis want to get into 9124. Our people want to get out. And that, in my view, 9124 ought to be repealed, but it will require a constitutional conference to do so. And Jane, can you maybe give us some insight into what will become legally of the term Métis, and in the event that the court rules that they are a part of 9124?
Thanks, Ken. With great respect, I don't actually think you want out of 9124. What you want out of is the Indian Act. Very different things. Very, very different things. So out of the Indian Act, that's when I'm negotiating the treaties in BC, I hear it every single day. We want out of the Indian Act. We want control over our own lives. We want to be able to look after our own kids. We don't want, we don't want to be we don't want the minister in Ottawa approving our wills, all of those sorts of things. It's the Indian Act issue. The idea of federal or provincial jurisdiction is a completely different question. So the way I look at it is that Indian in Section 35 does not mean the same thing as Indian in 9124. We already know that, I think it's a bit of almost not really the point of the exercise here, because we already know, Ken, from the 1939 reference case about what we called re-Eskimos back in those days. So we already know that Inuit are Indians, even though they're named separately in Section 35 as not being Indians, right? So I think if we were back in 1982 these days, we would have put First Nations, Inuit and Métis. Or, now I hear the gentleman up there wanting to use a different terminology, but you and I have been around this speaking for a long enough time to know that the language discussion and debate has been part of the ongoing evolution of us identifying who we are, right? We were Indians, we were then people talked about whether we would be in the Constitution. The serious discussion was, would we use the term natives, right? We used the term natives, we used the term aboriginal, we used the term this. So what is going on in Daniels is that the court at the trial level said, if we were going back again to the 1867 and redrafting 9124, instead of saying Indians and lands reserved for the Indians, we would have said Aboriginal people and lands reserved for the Aboriginal people. And so that would include the different kinds of Aboriginal peoples in this country. So the whole idea is that all Aboriginal peoples are a federal responsibility. That's the idea. Not that all Aboriginal people are under the Indian Act, but all Aboriginal people are federal responsibility. So I don't think it really affects the Section 35.
Good. So on that note, we're going to take our first morning break. Thank you for your patience. We'll do about 10 minutes and be back in our seats at just before 5 after 11. And again, we'll have the opportunity after our rapporteur's comments to have a broader discussion about all of the things we've heard and some of the other panels, and we'll also ask Jean and Bill to come back. So please join me in thanking Jean Teillet and Bill Gallagher.